It's about 20 minutes till 11. Call the meeting back to order. And we move now to tab G, discussion and possible action on the proposed amendments to existing rules regarding our electrical program. And who from the General Counsel's office is going to make that presentation? Lynn, there you are.
Thank you.
I was looking at the wrong place for you. I thought you were over there.
I'll go over there if you want. Lynn Latome, Assistant General Counsel. I didn't know if you wanted to hear comments first or if you wanted me to start first.
You know, I think I'd like for you to
Give you some overview?
give us some overview of it, and then we'll allow those who wish to comment on it before we take action.
Very good. Again, Lynn Latome, Assistant General Counsel. I'm here to present to you the proposed amendments to the existing rules at 16 Texas Administrative Code, Section 73, 51, 52, and 54. This rule amendment originated from the Electrical Safety and Licensing Advisory Board. They originally posted this amendment in the Texas Register on August 10th, 2012. The comment period closed on September 12th, 2012. 137 comments were received. The original posting expanded the definition of on-site supervision, and it specifically required on-site and general supervision by a contractor and a master of record in the disciplinary rules. The advisory board met on October 11th, 2012 to review the comment. In response to the comment, the advisory board withdrew the changes to the expanded definition under 7310 and recommended that the disciplinary rules under 7351, 52, and 54 specifically name general and on-site supervision as a responsibility of the contractor and master of record. As explained by the board at their October 11th meeting, they wish to activate the definition of on-site supervision by citing it in a disciplinary rule to create a prosecutable standard. The majority of the comment opposed the posted changes. I'm going to try to summarize those comments for you now and run through them briefly so you have in mind what they talked about. Many of the comments stated that there were no safety problems or incidents identified to call for a change in the current system. Without demonstrating the problem, this was an uncalled for intrusion into individual business practices. Many comments reflected that the current rules were sufficient. Municipalities already addressed supervision standards. Comments also raised that this would raise the costs to a struggling home building industry. Comments reflected also that this would increase costs doing business and raise housing costs. Comments reflected that this would cause small contractors to lose business and give an advantage to large contractors. One comment suggested that this would be a harassment tool for union contractors. One comment, several comments reflected that this would cause construction delays for there are not enough licensees to cover the job sites. Comments reflected that apprentices doing non-electrical work should be allowed to work unsupervised. One comment reflected that for sign work, more than one person cannot be present working on a sign many times, and therefore on-site supervision was useless and a potential OSHA violation. Comment reflected that the rule did not go far enough. It allowed one person to supervise any number of supervisees. Ratios were necessary. Comment reflected that trained apprentices should be allowed to work unsupervised. And lastly, several comments in opposition opposed the comment because this is increased government regulation. Comments in support of the posting stated that increased supervision will increase public safety. The apprentices should not be left for any length of time. Everything should be monitored. One comment was made that this would not increase costs to doing business. One comment proposed that this was a great start, but it will not work unless there are spot inspections. And lastly, comment reflected that without supervision, apprentices cannot get on-the-job training. Then there was a group of comments that were uncommitted, but raised questions and different ideas. Many of these comments stated that the language was confusing. On-site supervision should not be required at all times. How large the site was needed to be defined, or ratios created between the number of supervisors and the number of people they supervise. And lastly, one comment suggested that supervision was necessary. However, the state standards should be consistent with existing municipal standards. The comments were included in your materials in full. As this is a recommendation made solely by the advisory board, the staff has no recommendation. I'm happy to discuss with you anything you might like to talk about.
Did I hear that there was there'd been no violations or no safety
I didn't speak.
issues?
I didn't speak to that, and it might be better to see if our enforcement division can speak to that. I personally do not know of any enforcement cases. I simply can't answer that question. I don't know, and I don't know. There have been no problems that were specifically discussed in the advisory board meetings that this was trying to remedy, and no specific examples demonstrated that needed to be answered. So I can't provide you any information on that.
Commissioners, if it's okay with you, let's hear from our commenters on the subject, and then if we have additional questions of the staff, that we can come back to that if it's okay with everyone. Okay. It's on top of my stack, and you're sitting closest. So Randy Palmacall.
Thank you, Chairman Denton, Commissioners. My name is Randy Palmacall. I'm the owner of Randall electrical contractor company here in Austin. I've been in business 29 years, been in the electrical trade 41 years, and I'm on the advisory board. The reason for the proposed amendments, well, first of all, let me address the 7310 and the reason we decided not to move forward with that. It created a lot of confusion in the industry. And it wasn't our intent for that confusion to be created. It was a misunderstanding of what we've written. And so we just decided that it wasn't worth pursuing. However, we would like to have pursued it further. We decided not to. But the purpose of adding the language and that we're proposing, 7350, 152, and 54, is to be able to enforce what's already there. This recommendation was made by staff, Ms. Kaiser, when we asked her why supervision of apprentices was not being enforced. It was because it was only mentioned in a definition, and that a definition cannot be enforced, that if we wanted to enforce the supervision of apprentices, it would have to be in a rule. And that's why we're making this proposal. So that's the main reason for this. This wording actually came from Ms. Kaiser. And it was never our intent to have master electricians on every site, which was part of the confusion and the reason for getting away from 7310. And the supervision of apprentices, and you need to be familiar with the way our industry works. And that is, you start out in the industry as an apprentice, and you become a journeyman after you've completed so many hours of on-the-job training that have to be documented by specific persons as spelled out in the law and the rules. If a person is not supervising an apprentice electrician on the job, how in the world are they going to get the on-the-job training hours documented if there's nobody watching what they do? Now, you're going to hear a lot of cases where we do our supervision by going by the job in the afternoon and looking at what they've done. Well, you know, there's a big difference between supervising a person's work and going by and inspecting it. It's two different things, totally different. And that's what we're finding in the field. And the board is not intent, we're not trying to change anything that has anything to do with the way the industry operates. The industry's operated this way since it's been in existence. There have always been apprentices, and the apprentice worked under the supervision of a journeyman electrician. And after so many hours, he became a journeyman, and so on and so forth. And the journeyman has to have so many years in the trade to become masters. So it's progression, and all we have to document this progression are our license. That's all we have. And therefore, apprentices that are working out there unsupervised, they're not getting the on-the-job training like they're prescribed to get in the law. I have trouble on a lot of the comments that came back, and there was a stack that big, and most of those were confusion. But I don't understand the comments. I mean, the comments about raising the cost of a job. How can supervising somebody raise the cost if the guy's still there? How can small contractors lose an advantage to big contractors? they're supposed to be doing it right in the first place. And if you're not supervising your apprentice, you're not doing it correctly. You're not doing it with the intent of the law or the intent of how our trade operates. So the only thing we're giving the department with these changes is the ability to enforce supervision. That's all we're giving them, and that's something that they don't have now. So another item that was mentioned was that there was no facts or findings out there that really show the need to supervise apprentices any more than they already are. That data is incorrect. We find it every day. We go behind jobs, we make repairs, we see electrical work that would scare you half to death. And it's mind-boggling. And this is work that was done by a contractor, and he's supposed to be responsible for it. I'm sorry. The work's not getting done correctly. It is a dangerous situation. Eric Stromberg is on the advisory board too, and he explained during our discussion on this proposed change about how it's not whether the electrical works or not, it's whether it fails properly. And that you can put electrical in and the light will come on and it'll go off when you turn off the switch. But if something's wired wrong, number one, you can get shocked. Number two, it could burn your house down. And there's a lot of things about electrical that's just dangerous, and these people need to be supervised. You can't smell electric, you can't see it, but you can sure feel it. And when it goes wrong, it's typically catastrophic. So it's just something needs to be done so we can enforce the supervision issue. That it's the spirit of the law and the intent. It was never intended for apprentices to work alone. That's not what the law was written, and that's not the way our industry's ever been. They need to be supervised. So,
Any questions?
Thank you, sir.
Mr. Ned Munoz?
Mr. Chairman, members, Ned Munoz with the Texas Association of Builders. Certainly appreciate the opportunity to come before you all again. I know I've been here to talk about this issue on a couple occasions and appreciate your time on this. The Texas Association of Builders, if you recall, we represent essentially residential home building, 1 and 2 family homes. We've got about 10,000 members statewide, 31 local associations, represent 315,000 jobs and $21 billion to the economy. So this is something that is a big part of our industry and something that we're concerned about. I think that we can certainly agree in principle with not only supervision of apprentice electricians, but even with the definition. And I say that in principle. But the problem arises when you start realizing that there's a lot of confusion even on the current definition as it is. At the advisory board meeting, the electrician advisory board meeting, I did suggest, or I did say that I could not foresee any major problems with applying that definition. But I also made it very clear that I don't make those decisions for my association. My members make those decisions. And upon further reflection, they do have concerns. And I think those concerns are backed up by what happened immediately after my testimony at the advisory board, and that is this, that the advisory board members themselves had a discussion on what exactly does the on-site supervising licensee mean? Does the on-site part of that mean? One of the advisory board members even made a comment that something to the effect that he doesn't understand how you could supervise without actually being on site. We just heard Mr. Parmakal talk about apprentices should not work alone. And so this is where our concerns arise, is there is confusion on exactly what on-site means. I think if it said site supervising licensee without the on before it, we wouldn't have as much concern and problem. A lot of what these apprentices do shouldn't require immediate direct on-site supervision, such as digging trenches or nailing boxes, things like that. But when you have the confusion that I think arises with on-site, it's going to result in two things. Number one, the electricians themselves are going to have confusion what is on-site. And not now, is this going to lead to circumstances where they're going to have people on site during this type of work? Number two, and we heard it from TDLR just today, Ms. Latome. They're trying to create a prosecutable standard. So when we're talking about that, and there's no clear understanding or interpretation of on-site, is the department now going to interpret it as having to be on-site during this type of work? The IEC itself, after the advisory board action, had a newsletter, and in it, the newsletter talked about what this is before you today. What this would do is it would require the win of supervision to be ultimately decided by a SOA judge. And so now does this mean that these interpretations, as staff turnover occurs, as board membership turnover occurs, as leadership at TDLR turnover occurs, these interpretations could change exactly what on-site is? And the fact of the matter is that even if no action is taken today and no changes are made, the current regulations do state that a licensed electrical contractor and its designated master electrician of record is responsible for supervision of all licensees performing work on behalf of the contractor. That would include an apprentice. So currently, there is supervision required. And I guess it's the extent of that supervision and an application of a term on-site licensing supervision, which is not clear and is confusing, that concerns us. Because as we've testified in the letters, and as many of our members and others, including electricians, have written in letters, and as we've testified before, when you require too much on-site supervision over some of these areas that probably should not be supervised, such as digging trenches and nailing boxes, there's going to be construction delays, and that's where the increased costs occur. And I can tell you that's where the increased costs will occur for our industry, and that will those construction delays. You have financing that is accruing interest, and delays in themselves just tend to create an increase in the price of homes, which is something we're very concerned about. Again, we certainly agree in principle on the supervision aspect. We are just very concerned on the confusion within the electrical board itself, as well as our members, on what exactly on-site means. And I think that the fact that on-site could evolve into an interpretation that someone needs to be there at all times during a lot of this work that I don't think requires supervision, again, digging trenches and so forth, we're right back to where the concerns are in all the letters that wrote. And there were many letters, 137 comments, and I know that the vast majority of those comments were against this for the concerns that we're talking about, that I'm talking about today. So certainly appreciate the opportunity to talk to y'all. Certainly want to work with y'all. And I would respectfully request that y'all not adopt this today. Again, we can work with everyone on this going forward. I think that if it just said site supervising licensee, we wouldn't have this concern, because it does seem to appear that on-site question is what's causing a lot of confusion. So with that, I'll close. I certainly appreciate it, and we'll be glad to answer any questions.
Can I say one thing?
You have a question?
Well, I have a statement that says
Well-
general and on-site.
You know, let's talk about that during our deliberations, unless you have a question of the witness.
I think you can say that, is what I'm saying, general.
Oh, okay.
Okay. Well, I will say that when it says general and on-site, the on-site, the and means that on-site as well. So that on-site is what's going to be applied. And that's where our concern, general and on-site. But yes, the on-site will be applied, which is where our concern lies. Thank you.
Thank you.
Any further comments from other individuals?
I have no more witness affirmation forms. Is there anyone else that wishes to comment on this? Commissioners, on this subject, to give you a little bit of background of why we're here today, in 2004, this issue of on-site supervision was raised by the Electrical Advisory Board, and there was quite a bit of debate and discussion took place during 2004. And ultimately, the matter made its way to the commission, and the commission unanimously voted to reject the on-site supervision philosophy. And when this issue came up again this summer in discussions with the chairman of the advisory board, and I will say I was on the commission at that time and I opposed it at that time, and I still do oppose the language at this time. The reason it's on your agenda today is that in looking back at the record, only Commissioner Morgan, Moses, and myself were on the commission in 2004. So we've got some new commissioners who have not had an opportunity to weigh in on this. So therefore, I thought it appropriate and prudent to bring the matter before the commission for a vote again. As I stated, I oppose the measure, and quite frankly, I believe, as I believed back in 2004, we have in place a language and a provision which provides accountability and responsibility. And in all the discussions back during 2004 and during this matter, unless someone wants to correct me, there have been no incidents that specifically say that this needs to be changed because of problems that have occurred in the industry with the language that we already have. We have in place something that clearly states that the master for that job is responsible for and accountable for the work that takes place on the job site. And in my opinion, that has served us well, and I believe that to try to encroach on the subject and to try to put in some words and language are be extremely confusing to the industry, and I certainly do not think it would be advantageous for us to let a SOA judge start determining what is and is not appropriate as far as on-site supervision. And I think this is what very well might happen to us. If a SOA judge chose to do so and it became the law of the land that was the interpretation, I have some concerns from a small business standpoint. Let's say in the rural areas where you have a small electrical contractor with one master with several apprentices, he may have 2 or 3 jobs going at one time. And if we get some type of adverse ruling from a SOA judge and maybe even from a district court judge that dictates that on-site supervision has to take place 80% of the time, 20% of the time, 30% of the time, it very well would preclude that small contractor. You might cut his business in half because he physically couldn't be everywhere at one time. But yet his business is not large enough to support journeymen and additional journeymen and masters. So I think the language is going to add some confusion to an industry that's already struggling to get back on its feet. And I, for one, would recommend that we reject the proposal and go back to the language that's currently in our rules, which require accountability and responsibility of a master. So.
And you know, I live in West Texas in the middle of the oil boom, and we are short housing tremendously big time, and we can't even recruit master electricians or journeymen because we don't have anywhere to put them. And the biggest problem we have right now is we don't have enough master electricians and journeymen to oversee what we have. So it would be almost impossible to comply with it because of the shortage of what we got. I mean, if you look in the one ads right now, that's all you see is every company trying to hire more master electricians, journeymans, and all, because it's just such a boom. You know, you can't get high enough because there's no place to put the people to live. You can't build the houses because you don't have the people to do the work. You know, it's just ongoing and ongoing. But to try to supervise that would just be next to impossible with what we have going on.
Any other comments? Commissioner Moses?
Well, my comment would be, I would be, I think that we don't have any evidence to say why, current language is not working. And I would just be, with this thing of another intrusion of government regulations, of government oversight, I think is not healthy for our industry, and I just would not support something like this, to have another layer or something, another entity. Then it seemed like it would, and it would cost us additional. I think it would, in the end, it would, in terms of the supervision and what that would mean. And so I don't think it's healthy for what going forth in the industry to try and do something like this.
Commissioner Shaw? Yeah.
Well, I wasn't here in 2004, and I hope I'm not trying to digress from what the decision was then. But just a couple of items. First, I'm not sure if this is ready for prime time. Being a regulator and a code official, I understand language and I understand how to enforce applicable language. So my first thought, my first glance through this was, this is really not ready for prime time. Second, it's unclear that from an enforcement perspective, what the perception really is out there. I mean, what are we trying to do here? Are we trying to write language to clarify language? Are we trying to impose additional regulations or restrictions? I'm also looking at this, and we're struggling with a simple word as on-site. What does really on-site mean? On-site to a home builder could be an entire subdivision, whereas to a commercial building, it could be just that one pad site. Or for a mixed-use development, it could be an entire apartment complex. So what really is on-site, And so I really don't feel that this is ready for prime time yet.
Any other comments?
I guess my biggest question is, when we had so many electricians who seemed to be opposed to this regulation, even when it was watered down a little bit, I still don't see the need for it. I'm agreeing with Commissioner Moses, and I'm not seeing the big complaint in the industry or by the citizens of Texas that this needs to be addressed. When this was brought up in 2004 and over the last 8 years, it's not like we have this big outcry that we need this addressed. And I get concerned every time we add another regulation, because it just opens up another potential myriad of problems.
I do agree with you, and if we didn't, I think that we do have, and if we didn't have in place a measure which provides for accountability and responsibility, then I would think we would need to address it. But I believe that we have in place a standard and a rule of accountability and responsibility that, quite frankly, has been working. And I think to encroach or go further on this without, as Commissioner Shaw said, without a little bit more development of exactly what it is we're talking about, then I think it would be inappropriate. So I think I'm hearing from the commissioners a reservation about going forward with this. And
Okay.
is there more discussion or a motion we can make?
Yeah, I'd like to make a couple more statements before we deliberate on, onto the motion. As one that oversees a building regulatory department in a jurisdiction, in a city, in a municipality, this proposal would basically benefit some of my staff. I think my staff would welcome this, because we're pushing the burden of responsibility on having a individual out there who watches over every work that's been done. But But I say this with caution that how do you regulate supervision? It's practically impossible as a regulator to go out there and burden TDLR or any other jurisdiction to go in and regulate supervision. To go in there to make sure that there is somebody at the full 8 hours or 10 hours of work, that individual is present on site. So, anyway, I just wanted to add that comment in there just as a pro bono.
Well, and I've even been a victim of a poor, shoddy workmanship of electrical work, of having a place burned down. So, so I can see it from both sides, you know, of poor supervision in this. But like I said,
It's not as if there's no one responsible.
Yeah.
There is someone responsible.
Yeah,
We don't want
exactly, there's somebody
We already
responsible
have
for it,
someone
but yes.
Yep, Mr. Chairman, if you're ready for a motion, I'd like to make a motion that we deny the proposed amendment as recommended.
And is your motion that we
And we continue our
continue the current rules
rules?
with respect
Yes,
to-
yes.
have a motion to deny the recommendation and continue the rules that we currently have in place? Is there a second to that? Motion and a second. All those in favor
Can we
signify
have
by saying.
discussion on that?
Sure, if you have any additional discussion.
Yeah, we do have a second on that, so I will go ahead and offer this as a suggestion. If you are looking to hold somebody responsible or accountable, maybe the language needs to be tightened a little bit more to the master electrician. Who is the individual who's actually certifying that work? That's what we hold that person accountable for in a jurisdiction. So I will be I'll be voting in favor of the motion.
Have a motion and a second. Let me call the question. All those in favor signify by saying aye. Aye. Any opposed? Motion carries unanimously. Okay. Let's, if you will, Commissioners, take a look at, Ms. Mahon, do you have our memo concerning our advisory board appointments that you would distribute? Moving now to item number K, approval of appointments of members to advisory boards. Have a couple of recommendations to the commission with respect to that. Two are reappointments under our elevator advisory board, and the second is a licensed breeder advisory committee, a veterinarian appointment. We had a resignation from a veterinarian. Our advisory board calls for 2 veterinarians, and I interviewed and personally spoke with about a half, or maybe probably a dozen different vets who had applied for the job. And Melanie Mercer, all of them were qualified, but Melanie Mercer just stood out as a candidate that I think would make a good voice on the commission, on the advisory board. So I would ask for your approval of these reappointments and appointments.
Do we need to make a motion?
You do.
Okay, I move to accept the reappointments and appointments as recommended by Chairman Denton.